Mtazamaji, hebu tuelekee katika mahakama ya Milimani hapa jijini Nairobi, ambapo kesi ya Albert Ojwang inaendelea. Tuweze kujua kipi ambacho kinaendelea kwenye mahakama hiyo.
They have not averred to that effect. There is nowhere the applicant is saying the respondent is a flight risk or is likely to escape. And number one reason why the respondent is not a flight risk, why he is not likely to escape, and why they did not put that in their supporting affidavit is because the respondent is a serving police officer, Your Honor. He cannot escape and leave his job. That is what he does for a living. That is what sustains him and his family. There are averments to the effect that the respondent might interfere with witnesses. Your Honor, paragraph 3 of the supporting affidavit of the applicant. The applicant says they have already interrogated some witnesses. So when at paragraph 30 they say they will already interfere with witnesses, we are wondering if who are these witnesses that are yet to be interrogated? Because at one point they will interfere with the witnesses, at another point we have interrogated the witnesses. So where is the truth? If anything, Your Honor, this is a police corporal. Constable, apologies, Your Honor, is a police constable. It cannot be true when the applicant says he is a police officer. That is paragraph 32 of the supporting affidavit. It cannot be said that the police officer wields police powers. A police constable, Your Honor, is not capable of wielding any police powers in the context of these investigations. So, Your Honor, if we read the supporting affidavit from paragraph 15 all the way to paragraph 22, Your Honor, the applicant is saying the respondent is likely to. There is a likelihood the respondent will. There is a likelihood the respondent did. Your Honor, that just goes on to show that there is no evidence. Like my senior put it, they are mere apprehensions. There is no any evidence whatsoever that has been brought to this court to support the averments, and therefore they are mere statements which cannot be proved. So the conclusion of that authority, that is paragraph 14, and this is the upshot of this authority, Your Honor. I do not find that the police offered good reasons for the continued detention of the arrested person, because the matters they used to justify the detention, taking witness statements, obtaining call data, securing forensic reports, those are things that can be accomplished by the applicant without the physical need for the respondent. And that is why, Your Honor, we are asking that the application be disallowed, because the respondent is not physically needed for the applicant to carry out his duties. Now, Your Honor, there is a test that was established in the celebrated case of Oscar Sudi that my senior briefly touched on. This is Sudi Oscar Kipchumba versus the Republic. It's a criminal revision number 208 of 2020. Your Honor, in this case, there's established a double test that must be passed by the applicant for them to be able to detain the respondent. And these are the two tests, Your Honor. Number one is that there must exist exceptional circumstances. Exceptional circumstances for the applicant to want to detain the respondent. Your Honor, you have been told there are other people that are yet to be arrested. There is suspicion that other people were involved. From the deponent's own avowals, when he was here, he said some of the people are policemen and some are not policemen. If there are people who are involved together with the respondent, Your Honor, and they are not here, we do not know the extent of their involvement in this matter. So why would it be that the detention of the respondent is exceptional? Our submission on that, Your Honor, is that it is not an exceptional circumstance to want to detain the respondent. Number two, Your Honor, the second limb of the double test is the need for the applicant to use the least restrictive means. Least restrictive means. Your Honor, detention of the respondents cannot be said to be the least restrictive means for the applicant to be able to conclude their investigations. This court can release the respondents on reasonable cash or bond terms and impose conditions that will enable him to attend the court. This court can impose a condition that the respondent should not leave the court's jurisdiction, that the respondent will be able to respond to the IO or any investigator whenever he is called upon. It cannot be said that the only way for the investigations to be carried out is detention of the respondents. Your Honor, those are my brief submissions on the matter, and for that reason, we pray that the application be disallowed, the application by the applicant be disallowed, and the respondent be released on reasonable bond terms or cash bail terms. Thank you, Your Honor.
One word before, because we will not have time to do any submission. I apologize. My client tells me he had told me to pass his sincere condolences to the family of the loss of the deceased. He's a human being, and any family that has lost anybody is a big disaster to that family. And on behalf of his defense team, we also pass our condolences to the bereaved family, and may God give them grace as they deal with this sudden death. That's all, Your Honor.
Yes, may it please Your Honor, my name is Opundo. Your Honor, so we are both the applicant and the respondent at the same time, so I'll take it globally in my response. Yes. Yes. For the state. Yes. I'm a prosecutor. Your Honor, we humbly submit that the evidence which has been tabled before you in the form of the affidavit clearly lays bare the reasons as to why the respondent should be detained for the period that has been requested. The circumstances leading to the investigation by IPOA is not in dispute. And this has been categorically stated in the affidavit. there's no dispute that life was lost. There's no dispute that the deceased died in a police cell at Central Police Station, to be specific. And this was confirmed by the medical report which has been attached to the affidavit. And the OB extracts which have been attached. Which clearly demonstrate that the deceased was removed from the police cell, taken to Bangati Hospital, where he was proved to be dead. There is no intervening incident. There is nothing which intervened which could say that the deceased did not die out of the cell. That is clearly demonstrated. It has also been demonstrated in the affidavit that the respondent is the one who was manning the sentry at the time. There was no any other person. That has not even been disputed. And the key reasons, which are the key grounds why this application has been made, is that there is fear of interference with witnesses. And the reasons have been given in the affidavit, which clearly demonstrate that this officer, the respondent, is likely to interfere with witnesses whose statements are necessary and who are police officers. Your Honor, it's our humble submission that when it comes to the issue of rank, that's not what counts when it comes to interference with witness. Interference can take any form, any shape. You don't have to have influence over or bear any influence. Your Honor, it has also been submitted before you. It has also been laid bare in the affidavit that the nature of investigations are complex. And, Your Honor, this court, and it has been decided in several cases, when the courts can consider granting such application. And this, I'll enumerate them. We'll give authorities, I'll give the citation. One is the serious nature of the offense, which is under investigation. The second ground is early and sensitive stage of investigations. The third issue is the forensic and surveillance-based complexity of the case. And finally, risk of interference with ongoing inquiries. The facts which have been deposed in the affidavit clearly demonstrate the four grounds which I've stated. Your Honor, it has been submitted that the arrest of the respondent was a knee-jerk reaction. We submit it was not. It has been established as to when investigation in this matter began by IPOA. It did not begin yesterday. It did not begin with the arrest of the respondent. Your Honor, at this stage, we are dealing with Article 49 of the Constitution and not Article 50. What Article 49 expects of the applicant in such a case is just to lay bare before the court the justification for continued detention of a suspect. We are not talking about the rights of an accused person who has already been arraigned before the court, so as to apply the principles which are contained in the bail and bond, the guidelines which have been given. You know, there are compelling reasons to have the respondent detained to avoid interference with the investigation. Indeed, it is demonstrated in the affidavit that there was an attempt from the beginning, when it was realized that the theory of the suicide failed and it was established that the deceased was killed in a police cell, there was an attempt at interference or derailing the investigation from the beginning. And this has been demonstrated with attempts to destroy the data in the CCTVs. That is demonstrated, and it's not in dispute. A person who from the beginning wants to destroy the evidence, that is a person who will go all the way to interfere with any kind of incriminating evidence which may be unearthed by the investigation. And this is not just a mere preemption. There is all the likelihood. Your Honor, it has been stated that there are other suspects who are, include even police officers, who are likely to be arrested. They are out there. There are people who are known to the respondent. It has been decided in the case which we will cite that where a suspect is likely to be out and communicate with witnesses and even other suspects who are still on the run, he should be denied, he should be detained when investigations are ongoing. You know, the investigation in this matter is still at very early stage. And it has been demonstrated how sensitive this matter is. Your Honor, we submit that there has been an attempt. It has been demonstrated that the investigating officers have been finding it difficult to retrieve information from the police officers. Requiring the more reason why the suspect who is in custody should remain in custody for the few days which have been requested. Your Honor, I want to respond to the authority which you were given. This is miscellaneous of criminal application number 26 of 2018. This one now with Betty Gemtai, Kimea applicant, what is public. At the onset, Your Honor, I wish to submit that this was an application dealing with the extension of time after an applicant has been detained. It does not apply to this instant case. Your Honor, we submit that there are justifiable reasons for continued detention of the respondent before the court. Article 24 of the Constitution allows for limitation of freedom. Regard only need to be given to the importance of that limitation. The importance of the limitation which we are seeking is to enable investigation to be completed without interference. It will be total injustice, travesty to justice, if investigation were interfered with. At the end of the day, there are no witnesses, there's no tangible evidence being presented before the court because a suspect interfered with the investigation. It will be a disservice, in fact a dishonorable thing, to the family who was lost. It goes even a long way in protecting victims of crime. Which this court has a duty to do. Your Honor, we finally submit that the investigation here has been established to involve issues of forensic and surveillance. And part of it has been demonstrated in the affidavit that it takes a process of trying to retrieve data which had been attempted to be interfered. And it has been stated by the investigating officer on oath that this is something beyond him. It's done by an expert outside within his control. He may not have control over that. And the days which have been sought, Your Honor, are reasonable in the circumstances. We are not saying that the applicant, the respondent will not be given a fair hearing. Once the investigation are complete, if it's charged, will have his fair hearing expressed, have his day in court with all the rights of an accused person. We are just protecting the evidence to be tendered. You know, on the authority which you have given on the issue of calculation of days, you know, we submit that there is no mischief in the application which you have been made. In any case, that does not go to the root of the application, even if you were to apply the rule of computation of days. These are mere procedural issues and does not touch on the tangible aspect of the importance of carrying out investigation and requiring days. "21 working days requested is not a mystery. It's an estimation in the sight of an investigating officer. And this, to the investigating officer, could be just a matter of nomenclature. He could maybe, to him, he would have asked for 30 days. But it's workable, it's grantable. We urge you to allow them. Our application for detention for 21 days and reject the application for bond at this time, as we jeopardize the investigation in this case.
If I may, my name is Kinoti from IPOA. My Lord, let me first say we agree entirely with the submissions made by the Learned Counsel for Prosecution.
Point of objection. I don't know under which provision an investigator will address you, because the investigators in this matter are IPOA. The officer who deponed the affidavit has given his side of the story. IPOA cannot submit. It is a preserve of the DPP. IPOA is a witness that we have cross-examined. And therefore, if IPOA has anything to say, let it hand over that to the DPP. The DPP should not cede ground to this crucial matter. IPOA cannot prosecute, it can only investigate. Article 157 mandates the DPP to be the mouthpiece of IPOA. So, Your Honor, we object to IPOA being allowed to address the court.